Facing a criminal charge in Indiana can feel like you've stepped into the unknown, a world of rules, procedures, and language that no one can understand. Of course, that can be scary. One of the very first steps in the process when you're charged with a crime in Indiana is a hearing that's called the arraignment, or the initial hearing. At the arraignment hearing, the court formally tells you what you've been accused of and explains your rights in a criminal case. My goal here is to give you a better idea of what Indiana courts are required to do at this stage in order to make the experience a little less intimidating and help you feel more in control. An arraignment isn't a trial. It's not where guilt or innocence is decided. Instead, it's a procedural safeguard, an official, required step to make sure you're clearly told a few different things. First, exactly what you've been charged with. Second, your rights under the law. And then third, what plea you intend to enter. In Indiana, the arraignment is sometimes called an initial hearing, especially in misdemeanor and lower-level felony cases. But no matter what it's called, the court's responsibilities are exactly the same: to make sure you're informed and that your constitutional rights are protected. Under Indiana law, the judge must do a number of different things during your arraignment hearing. So let's talk about each one of these in turn. First, the court must read, or at least clearly summarize, the criminal charges that have been filed against you. That means the judge is going to tell you exactly what the offenses are that you're accused of, the classification of the offense, whether it's a misdemeanor, a felony, and what level of offense it is. Then the judge is going to tell you the statute or the law that the state claims that you've violated. Now, at any point in time, if you don't understand the wording, you have the right to ask the judge to explain it in plain language. Next, the judge is going to explain to you your constitutional and procedural rights. And that's going to include your right to an attorney, your right to remain silent, your right to a jury trial where you are presumed to be innocent, your right to confront, face, and cross-examine the witnesses that the state has against you, your right to require the state to prove your guilt beyond a reasonable doubt. Now, if you're not able to afford an attorney, the judge also will explain to you how you can request a public defender. In Indiana, that usually means you fill out a financial affidavit so that the court can evaluate whether or not you qualify for appointed counsel. Third, the court must tell you the maximum possible sentence and the fines for the charges that have been filed. This isn't to scare you. It's just so that you fully understand the stakes before making decisions about your court case. Fourth, the court is going to ask you to enter a general plea. And in Indiana, that means a plea of guilty or not guilty. And if you don't have an attorney, it's usually best just to plead not guilty. And in fact, here in southern Indiana, most judges will simply enter a formal plea of not guilty on your behalf without you doing anything. Fifth, the court is going to set the bail or the conditions of your release. So if you are in custody, the judge will address whether you can be released before trial and under what conditions. So that will involve, most likely, the setting of an amount of bail or bond that you must post in order to secure your release. Secondly, the granting of release on your own recognizance is possible, and that means that no money would be required, but certain conditions may be placed upon your release. Next, the court will address if there are any restrictions on your release, such as maybe a no-contact order as it relates to a witness in the case, or if there is a license or some type of travel limitation that you might have during the pendency of the case. Indiana courts must consider factors like the seriousness of the offense, your criminal history, and the risk of you not returning to court when it's making determinations about what the bail amount should be. Sixth, the judge will give you the date for your next court appearance, which may be a pretrial conference, a motions hearing, or a trial date, depending on what type of case it is. In most instances, the first hearing you're going to be going to after the initial will be a pretrial conference, and that's your opportunity to meet with the prosecutor and to negotiate the outcome of the case. Now, it's natural to feel like everything is kind of out of your control at the arraignment hearing, but you do have a voice, and there are some things that you can do to protect yourself during this hearing. First and foremost, you need to ask for clarification if you don't understand something. Second, you avoid discussing the facts of the case. Now, this is absolutely imperative because during the hearing, it's being recorded. Anything that you say can be used by the prosecution against you during the prosecution of the case. Now, the other things that you can do are to write down your court dates and keep track of those. Write down any conditions that the court has placed upon you. You don't want any of those things to slip through the cracks, and you don't want to miss a court date for sure. Next, and finally, you need to make the court aware of your need for an attorney or your need for public counsel or public appointed counsel if you cannot afford an attorney. Being arraigned, as I said, can feel overwhelming, but the law is really designed to ensure that you aren't left in the dark. If you are looking for a criminal defense attorney, a tested, experienced trial attorney, then reach out to me today. Initial consultations are free, and I'll help you navigate through this process, and you'll feel confident knowing exactly what to expect around every corner. Thank you so much for visiting me, and I look forward to talking with you here soon.